Good morning to all. At times, even certain things strike the minds of advocates who are actually practicing dealing with trial courts, because the trial courts are the basis where the documents are studied, evidence is let in, arguments are heard, legal points are raised by other parties and other things. Then the other thing is that the courts are burdened with pending of thousands of lakhs of cases in all the stages, either in trial court or appellate court and high court or in Supreme Court. Here, the thing is, certain things are settled. We say settled law. Suppose a particular claim is time barred, then he is not actually entitled for the relief. But this is found out at the completion of the trial, and even admittedly if the claim is barred, automatically his claim will be dismissed. Either he may be plaintiff or defendant making a counterclaim or set off. If the claim is barred by time, it will be dismissed. At times, while drafting the plaint, a plaint, we'll say we are concerned with plaint. Here, the plaintiff cannot plead law while put forth in his case in a plaint. Only facts are to be pleaded. When you plead facts, the advocate who is well versed with the law, he molds this fact basing on the documentary evidence or the evidence that may be put in by the plaintiff. Then basing on this, what is the relief you want? Not from the advocate, from the court. Then the advocate also applies his mind that what is the relief we are going to give and what is the relief the client seeks from the court. Then that's why the relief is framed. My point here today is that when a wrong pleading is taken, facts are pleaded. Facts we cannot whatever the client says, we have to. At times we may frame his case, but facts remain same. But while framing the suit, this fact may come down. This fact may at times this fact may not be pleaded. This fact is not necessary. These things advocates they think while drafting. When the matter comes up for trial or arguments, when the evidence is over, matter comes up for arguments. At times, usually the other side points out, sir, this relief is not maintainable under law. He cannot seek relief from the court basing on the pleadings. For this particular point, I am stressing here. The contention of the other side is that this man is not entitled for the relief as claimed in the suit. Then what is the duty of the court? Would the court keep quiet or suggest to the party that because the client is paying two fees, client is paying fees to the advocate to represent his case, client is also paying court fees, we should not forget. He is paying court fees seeking justice from the court now. In India, plaintiffs pay court fees. So there is a duty cast upon the court also to advise at the time of at the threshold, in the sense at the time of trial itself, that so the other side has taken an objection that particular relief cannot be granted based on the valuation you made or the pleadings you made, but actual relief what you want, whether the court hands are tied. My question is here. Whether the court hands are tied to peep into the matter that when the client pays court fees, that because of the pleadings or because of the mistakes in drafting the pleadings or because of the mistakes in adducing the evidence, in not bringing the correct evidence to the court, then court has got every power under civil procedure code that even court can call a stranger, not the parties or their witnesses. Court can call a stranger to the suit asking him to give evidence on this particular point. Then definitely truth may come out, because both parties, for the reasons best known to them, both may avoid that particular person who is competent to speak on the particular fact alleged by both parties. On the other hand, if this point is not addressed here by the trial court, I'm not whether it applies to any stage. At the first stage, rather whether the matter is filed and decided at the first stage, there I am. Whether the court is helpless, simply saying that basing on the pleadings, I cannot give the relief. Take it. Suppose a man asks for a partition of his particular suit. I'm giving the example for better understanding. But that sale is executed by 7 persons, including himself. His contention is that I am not a signatory. Can he seek for cancellation of that entire document, or to some extent that his portion is concerned in the subject matter of the suit, suppose a particular house? Then he files a suit for partition. Then court gets a doubt whether you have to seek cancellation of this document, or whether the suit for partition is sufficient. Then you come to the help. You address the parties, address the client. Client pays the court fees, or you simply dismiss the suit, making again go to appellate court, or the appellate court till Supreme Court. Matter is open. Then I am worried about whether the court hands are tied at the time of doing trial or at the time of hearing the arguments at the trial stage, that you have to seek amendment of your plaint if you want your relief. Are the hands of the court tied? Because ultimately the advocate who represents the party is not the sufferer because of the wrong pleadings. We cannot say such that, my dear friend, you go to a correct advocate. Who is correct advocate? I am not a correct advocate. I must be corrected by myself day by day. Everybody. At times, even legal point may miss even to the senior advocates also. I have seen number of instances that junior advocates, they help the seniors. They are supposed they should grow up like that also. Then I across regarding settlement of cases before Lok Adalats. Usually, it is an open secret where the matters are settled by both the advocates at some stage, and the compromise is reported to Lok Adalat, and Lok Adalat saying that they are recording the compromise. There is no issue for that. But at the first hearing stage, there is Order 10, if implemented by the trial court, Order 10 CPC, if implemented, my conscience say for the last more than 32 years, 35 years I am here in the bar. But this Order 10 is not implemented. To my knowledge, to my limited knowledge, rather I don't speak for others. To my knowledge, where I practice, this Order 10 CPC, if implemented by the courts, the rules say at the first hearing of the suit, the court shall ascertain from each party or his pleader whether he admits or denies such allegations of fact as are made in the plaint or written statement, if any, of the opposite party, and as are not expressly or by necessary implication admitted or denied by the party against whom they are made, the court shall record such admissions and denials. If it is done, suits will not be dismissed on technical grounds. Because my grievance is that most of the matters pending in higher courts preferred against the judgments of lower courts are these are the things where certain mistakes were committed while drafting, while leading evidence, while arguing the case. And the other rules also say that, I'm not reading out, direction of the court to opt for any one mode of alternative dispute resolution, and parties can be referred under Rule 1B to the conciliation, and there also conciliation authority may also direct whether it is fit case to be compromised, or it can be referred to the court again. And here, other than Rule 2 empowers the trial court at the first hearing of the suit, the court shall, with a view to elucidating matters in controversy in the suit, examine orally such of the parties to the suit appearing in person or present in court as it deems fit, and may orally examine any person able to answer any material question relating to the suit, by whom any party appearing in person or present in court or his pleader is accompanied. At any subsequent hearing, the court may orally examine any party appearing in person or present in court, or any person able to answer any material question relating to the suit, by whom such party or his pleader is accompanied. Even the court may, if it put in the course of an examination under this rule, questions suggested by either party. And ultimately, Rule 4.2 says, that any party refuses or is unable to answer any material question related to the suit, which the court is of opinion that the party whom represents ought to answer, and is likely to be able to answer if interrogated in person. The other should, even if such a party fails without lawful excuse to appear in person on the day so appointed, the court may pronounce judgment against him or make such an order in relation to the suit as it thinks fit. More than this summary nature, we cannot find anywhere as contemplated in Civil Procedure Code. But here this part is neglected. Court is, I am not criticizing the court. I am stressing the point that the client who pays the court fees cannot be denied justice, that his particular pleadings are not framed legally. As we say, the pigeonhole theory while we study law. Even the Honorable Supreme Court number of times stated, I can quote the judgment also, that it is the duty of the court, a trial court or any other court, to give relief. Why a man is approaching court? He wants some relief. He has got some grievance against other man. That's why, at times, one may be a wrongdoer among two, or both may be wrongdoers, wasting time of the court. But whether court is not empowered to see that some relief is granted, though Supreme Court, Honorable Supreme Court stated that give relief, that even that may not be pleaded, but basing on the facts and circumstances of each case, particularly the trial court, by using this Order 10, CPC, can do wonders. And we can save time also. We are not having time. Before settlement of issues, if both parties are addressed by the court, even with the assistance of lawyers also, representing both parties, and at any point of time, if the lower court is imposed, the trial court, rather, I insist upon trial court only, that the client who paid the court fees can be given some assistance by the court, because advocates are, okay, they represent, advocate represents his own client's case. He believes that his client is right at times. He should believe also, then he defends his case. The advocate will do his duty. Then what is the duty of the court? To say that, or to address the client, that the relief molded cannot be granted to you basing on the pleadings, these pleadings. You have to amend your pleading. Is it not the duty of the court, when you receive court fees from the plaintiff, to suggest that if you proceed further basing on these pleadings, you will not get your relief on the technical grounds? I am worried about only technical grounds, not on fact. If the fact is against him, he will face the music. But facts are good, case is genuine, but a particular prayer is not framed, or particular legal point is not pleaded in the plaint, but because there is a bar, only a defendant can take inconsistent pleas. He can plead law also, not the plaintiff. Either we should, the legislature, rather as the judiciary, should amend this, that plaintiffs can also plead law, or court which receives the court fees will address the parties under Order 10 and other rules therein, along with other provisions also, to give proper relief, to give some relief, or to give the entire relief, not basing on the errors or the mistakes committed by draftsmen. Let us hope that we are not here to dissect a person who comes to court. A person comes to court with some grievance. What is the actual grievance must be understood by the court, by the lawyers also. And you cannot dissect the plaintiff who comes to court into part. You have not pleaded this one, you have not filed this one. What are the documents filed? You judge basing on the documents filed, or you advise him. Who? The court and the advocates also. My grievance in this brief hearing is that plaintiff cannot be dissected, and on technical grounds genuine relief cannot be denied. If it is found genuine, and we cannot make him to run from pillar to post. Even at the appellate stage also, the same thing that is found by lower court, it will come up for hearing. He cannot escape. At times, even for amendment also, if he wants to go for some amendment of relief, by the time that the matter reaches the higher courts, the relief will be time barred. Though amendment relates to back to the filing of suit, but law of limitation is not like that. Because there is suppose cancellation of document, rather say, then only 3 years as per Court Fees Act and the Limitation Act. under which provision the relief is to be valued. These are the technical grounds where the advocates, rather, I am not blaming my community, my fraternity, but we are not clearly appreciating the settled laws. Here we have to address the advocate ourselves, we have to address ourselves. But here I will be thankful that if this part is addressed, that whether court is tied, court hands are tied in helping the plaintiff or claimant when his claim is not drafted properly. Cannot the court ask him, because both versions are there with the court, that you do this amendment, or just you make alternate prayer, or give up this relief, go for another relief, like that. Thank you.